Good morning, Judge Nuku.
Good morning, Chief Justice, and good morning to the commissioners.
How are you this morning?
I am well, thanks, Chief Justice, under the circumstances.
You are ready for us.
Well, I am here, Chief Justice. That's all I can say.
Yeah? You are kind of ready.
I am, Chief Justice.
You are ready. Okay, all right. Well, let me take this opportunity to thank you for making yourself available for an interview by this commission. We welcome the fact that you have made yourself available and you have come to subject yourself to the interview. Yesterday morning, this commission had a meeting in which one of the resolutions it took was to adopt the criteria for the selection of candidates for judgeship. Included in that document is a commitment by all of us here that we will ensure that every candidate is treated with respect and courtesy, but that doesn't mean that there will not be robustness in questioning. So where it's necessary, there will be a robust questioning, but all of this will be done with due regard to the candidate's human dignity, and there will be respect. So no matter how the questioning might be, never think that there's anybody here who wants to just treat you unfairly and so on. You understand?
I do. Thank you, Chief Justice.
Thank you. I will ask you some questions, and thereafter we'll give the Judge President of the Competition Appeal Court an opportunity to ask you questions, and thereafter the Minister and all the commissioners who may wish to put questions to you. Okay?
Yes.
Thank you. Let us start with your qualifications. You have a BProc degree and an LLM. Sorry?
Oh, I thought you were done, Chief Justice. I was going to say that is correct.
Yeah, yes. And then, but you have got a diploma. Is that right?
I do have a diploma in corporate law and a certificate in insolvency practice, yes.
Yes, yes. Now, before you were appointed as a judge in the High Court, you had practiced as an attorney, is that correct?
That is correct, Chief Justice.
Were you admitted in 1996?
I was admitted April 1996, yes.
And you were appointed as a judge in 2016?
1st of July 2016 was the effective date, yes, Chief Justice.
So that would mean that by the time you were appointed as a judge of the High Court, you had been practicing as an attorney for about 20 years, is that right?
More or less right, except that I started acting during April 2015, and my acting stints were continuous until my appointment. So it would be 19 years as a practitioner proper, and then started acting in 2015 until my appointment.
Yes, but nevertheless, you practiced for a long time.
That's correct, yes, Chief Justice.
Yes.
That's correct.
And your practice, how was the diversity of your practice in terms of branches of law?
We had more of a general practice, Chief Justice. Initially, we started off with criminal work. At that time, legal aid used to give instructions to attorneys. That's where we started, and we developed into MVA. I then took it upon myself to qualify as a conveyancer and a notary public, and we branched into that area. I had always had an interest in commercial matters, hence you'll see that I did this diploma in corporate law and subsequently did my master's in commercial law, which incidentally included a module in competition law. We did have some commercial matters that we were fortunate to deal with, but I must just confess upfront that we never did competition law as when I was in practice.
Yeah, well, not many black practitioners get to receive instructions or briefs in competition law and commercial law, serious commercial law matters, isn't it?
That's correct, Chief Justice. It was a challenge and still is a challenge.
Yes.
But nevertheless, I was never deterred because I did my master's I finished them in 2011. I still had not given up. My interest in competition law started during the early days after the enactment of the Competition Act. The Competition Commission used to run some public awareness seminars and workshops, some of which were held in Cape Town. I attended some of those, and that's where I really picked up this interest. And I thought that democracy had brought with it an opportunity for us to branch into those areas, but unfortunately it was to be a dream deferred.
Was there a specific purpose why you chose to do a master's that had a master's in commercial law as such, seeing that you did not have a lot of commercial law in practice?
I was always hopeful, Chief Justice, that at some point in time, the opportunities would come my way. And I wanted to prepare myself for the time when the opportunities do come so that I would be ready. Because it is one thing to hope that you might get an opportunity and you get it and are not prepared. So I was preparing myself for an eventuality if the opportunity knocks on the door.
That's very good. And then you said that one of the papers you wrote for your master's was in competition law.
Yes, Chief Justice. My master's was a combination of coursework and a minor dissertation. So one of the modules in the coursework was in competition law.
Yes. You would have written a dissertation. What was your dissertation on?
My dissertation was in company law.
Yes. And what was the topic?
I dealt with the codification of the director's duty of care, because the introduction of the new Companies Act had codified the director's duties as opposed to the position that existed prior to that, because they were dealt with in terms of the common law. And I did a comparative analysis between the South African company law. I also looked at the UK company law, which, as I understand, that our company law derives mostly from the English law. I also did a comparative analysis with the position in Australia.
Yes. Now, you have been a judge in the High Court since 2016. That gives you about, what, 6-7 years as a judge?
Close to 7 years.
Close to 7
6
years.
years and a couple of months, short of 7 years, yes.
Yes. Now, of course, if you are appointed to the Competition Appeal Court, you would be sitting on appeal over decisions of the competition tribunal, is that right?
That's correct, Chief Justice.
And generally, the competition tribunal consists of specialists in competition law, am I right?
That is correct, Chief Justice.
And those people would may have more experience in terms of competition law than judges who might come onto the Competition Appeal Court who might not have had a lot of exposure in competition law, is that right?
That's correct, Chief Justice.
How do you feel about that? Namely, sitting in an appeal court over a specialist tribunal which has got specialists or experts in the field of competition law when you might not have had the same exposure?
Let me just start by saying that, Chief Justice, I have done a scoping of the work that the Competition Appeal Court has done in its first 5 years and in the last 5 years. The majority of the matters that come before the Competition Appeal Court are procedural matters, interlocutory applications. And then you have matters that would concern core competition issues, which would mainly relate to Chapter 2 of the Act. When it comes to the fact that the tribunal members may be more experienced than me, and I must sit as an appellate judge in respect of their findings. It is, to me, Chief Justice, it still seems to be that the whole exercise is about the interpretation of the statute, it being the competition law. Generally speaking, the principles of interpretation apply across the board. What is a little bit different in respect of the competition law matters is that there may be some economics that come into play. But how you deal with that is the same way you deal with evidence in a medical negligence claim where you will have had experts, because it's the evaluation of the evidence based on the framework of the law, the principles are set out, and you evaluate whether the facts as presented drive you to a certain conclusion. So on its own, I don't think that it is an impediment. And I will also be sitting with colleagues who may also have more experience than I have. In the few matters that I have sat in the Competition Appeal Court, I have learned a lot. The colleagues there are very helpful. The matters are debated extensively. And when the judgment is ultimately returned, you feel that you understand the issues. That's all I can say, Chief Justice.
Yeah, well, I was not asking the question because I think it should not happen. But in our legal system, it happens. It has been happening for a number of years. The Labor Court and Labor Appeal Court had the same situation for a long time after the two courts had been established, where the judges in the Labor Court used to be judges with lots of experience in labor law and expertise, but the judges in the Labor Appeal Court, some of them didn't have a lot of exposure. So, but even before 94, it happened in labor law. You had specialist tribunals such as the Industrial Court, but its judgments would end up through a review process in the, an appeal process in the Supreme Court of Appeal now, you know. So it does happen. So you shouldn't feel like it's something that doesn't happen. But you would accept, would you not, that even when it comes to interpretation, you can't just say it's just the interpretation of the Competition Act. Understanding the concepts of competition law and the dynamics becomes quite important, because if you don't understand the basic principles of competition law, you could think a particular interpretation is correct when you think about interpretation, but in practice, it could cause a lot of problems in the industry. Is that correct?
That is absolutely correct, Chief Justice.
Yes,
That
yes.
is correct.
Now, you have, how long have you acted in the Competition Appeal Court?
I acted from January last year, Chief Justice.
Have you acted continuously up to now?
The appointment is for a year, yes. So it was for last year, and then this year again I was appointed until the end of the year.
Yes.
But the court does sit, say, once a term, and sometimes you may not sit in a term.
Now, if you were acting in the High Court or in any of the other courts for that period, you would have done a lot of cases, and you would have gained a lot of experience, because there are lots of cases in other courts. But is that the same situation in the Competition Appeal Court? Has this given you a chance to do a lot of cases?
No, it's not comparable, Chief Justice. As I say, in a term, you may find that you sit in one matter. For example, last year, I think the matters I sat in last year, I sat in 3 matters last year. The 4th one I was going to sit in was settled. And this year, then I sat in my 4th matter. So the matters that I've sat in the Competition Appeal Court from last year to date are 4 matters.
Yes, it's a very limited number of matters.
It is.
Yes.
I accept it is.
But obviously, that must be because of certain challenges in the Competition Appeal Court. It's
It
not,
has to
it's
do
not because
with-
you were not available.
Yes, it has to do with the flow of work from the tribunal to the Competition Appeal Court.
And how many judgments have you written yourself during that period?
I wrote 1 dissenting judgment and 1 judgment which was unanimous.
Yes. Do you believe that having written only 2 judgments in an area in which you didn't have a lot of exposure before has prepared you enough for a permanent appointment in the specialist field?
Chief Justice, with the training that I have also been exposed to during the period that I have been acting, I believe so. If you look at the judgments that come out of that court, I don't think that there is any year where you would find that there is more than 15 judgments on SAFLI. So it is that kind of an environment.
So you don't think that it's a situation where you should get more weight and get more cases to just gain more experience? You think it's enough?
Well, Chief Justice, I would accept if, on consideration of my broader experience, the Commission comes to the conclusion that I still need some exposure. But from my perspective, if that limited experience is taken together with my broader experience that I have from the High Court and as a practitioner, I think that has equipped me enough for consideration for appointment into that court.
Yes. And in terms of your High Court experience, have you sat in many appeals, full bench appeals?
I have, Chief Justice. In the Western Cape, there is a practice that during the first term and the third term, the first week is reserved for full benches, where you will sit in no less than 2 full bench appeals. So from 2016 up until the 2020, that was continuing. And then, of course, COVID disrupted that. But then after that, we went back to that. So I've sat in a number of appeals, full bench appeals. Also, there are appeals that emanate from the lower courts, regional courts, and the magistrates' court. I have sat in a number of appeals in that regard.
Yes, thank you. I will now give the opportunity to the Judge President.
Thank you, Chief Justice.
Thank you. Good morning, Judge Nuku.
Morning, Judge.
Judge Nuku, I just first wanted to ask you about the volume of work that comes to the Competition Appeal Court. In other words, if you were to have to wait another day when you might have had more exposure to the cases, if the volume continues as it is at the moment.
Sorry, Judge President, may I ask you to speak up a bit?
Sorry.
Yes.
I just wanted to ask you about the volume of work that comes to the Competition Appeal Court. In other words, if you were to be faced with a situation where it said that you needed more experience of the cases, if the volume continued on the basis that it is at the moment, how long would you have to wait until you'd gained 10 cases or 15 cases under your belt, if it was continued at the level of the frequency it is at the moment?
It would take very long because, as you would know, if you write 2 judgments in that court in a year, that's a lot. It's rare that you'll find a judge who has written 3 or more judgments, So it would take quite some time.
Okay. Of the judgments you've mentioned that you've written 2, the one I know is related to dominance in the e-media case, is that correct?
That's correct, Chief.
And what was the other judgment concerning?
The other one was concerned an application for temporary stay of a review,
Okay.
which we decided now in March, on the 24th of March. So it was more an interlocutory application.
All right. Can I then get to the approach that you might take to the interpretation of the Act? Do you consider that some knowledge of economics is essential for a judge who's wanting to interpret the Competition Act?
It is essential because you have got to be able to evaluate that evidence. You must be able to make sense of that evidence so that in your interpretation of the Competition Act, you attach proper weight to that evidence.
And do you feel that you've had some exposure to those issues through your course at the university and through the seminars the courts have done and cases that you've sat on?
The seminars have really been very helpful. In the matters that I've sat in, including the ones where I did not write a judgment, I got a good exposure to that. One of them related to Section 4, which is one of the issues that come often to the Competition Appeal Court. The other one you mentioned is the one that related to the abuse of dominance, an issue which also comes often to the court. The other area that is reserved for the Competition Appeal Court, the merger control, I was only involved in a matter which concerned procedural issues determining the rights of participation by a party in the merger proceedings. So I have kind of had a broad overview of the business of the Competition Appeal Court, I would say.
Do you have a philosophical approach to how to interpret a competition statute. As you probably know from the seminars, there's a great debate between what's called the Neo-Brandeis school of thought and the traditional Chicago school of thought, and some people are somewhere in the middle of those two schools. So in other words, if you are faced with a particular case and you've got to interpret some of the terms in the Competition Act, do you have a guiding philosophy as to how you would interpret difficult language in the Act?
I think South Africa is in a unique position because if you look at the Competition Act itself, it's broader than what other jurisdictions carve out as competition law. I say this because it makes it plain that there is public policy considerations that come into play. So my approach should be to ensure that the interpretation I give to the Competition Act is aligned firstly with the Constitution, and secondly, it is designed to achieve the objectives of the Act, which include competition proper in its sense, as well as the public policy considerations.
So if I can be more specific, if somebody said to you the Competition Act should only be concerned about, when it comes to prohibited practices, about whether the practice leads to higher prices or a reduction in supply, would you regard that as appropriate or too narrow an approach?
That would be too narrow in our context, in the South African context.
And so if it's too narrow, what other criteria would you then look at as being relevant?
Well, the Act, Section 2 makes it plain that one of the concerns of the Competition Act is the social and economic welfare of the consumers. So I would also factor that into the consideration.
Okay. And my final question is, if you were to be appointed to the court, historically many of the judges appointed to the court have gone to higher places. Would you be willing to give a commitment that you would be available to serve on the court for at least a minimum of 2 years?
JP, I would, because as I explained to the Chief Justice when he was questioning me, I've always had a particular interest in competition law. I made myself available for consideration for appointment into that court because of my appetite in competition law.
Thanks, Chief Justice.
Thank you, JP. Minister?
Thank you very much, CJ, and good morning, Judge.
Good morning, Minister.
Yeah, I only have one question for you. With the coming into effect of the Competition Amendment Act, we now see the Competition Commission embarking more on market inquiry. Do you think it will have any effect on the issues of access to the markets and dealing with issues of abuse of dominance by the various role players in the markets that they choose to proceed with market inquiries?
Minister, I think the amendments have brought about, the amendments would have far-reaching consequences in the sense that my reading of the Competition Act is now that upon conducting that market inquiry, the Competition Commission is then able to make its findings and suggest some remedial action which is binding, something which is akin to that which prevails in respect of the public protector. So now it's not only a question of looking at the structure of the market and this distortion, it has to make recommendations as to how those are dealt with going forward, which is, in my view, a very welcome intervention, because there had been market inquiries before which would come up with recommendations, and as you would know, there was nothing much that would happen in the way of those recommendations being implemented. But my view is that at least the amendments now have given teeth to the Competition Commission to deal with the structural problems. Because the competition issues, in my view, can be looked at in two ways. There is an issue that pertains to the conduct of the market players, and then there's an issue that deals with structural issues. So the market inquiries are designed, in my view, and can achieve a lot in respect of structural issues.
So do you think this could have the intended impact of having small players also having access to the markets if the market inquiries are used effectively?
The Act makes it clear that that is one of the mandates of the Competition Commission. And upon embarking on those market inquiries, the Commission is able to identify problem areas and is able to recommend solutions. So I think it can have that effect, Minister.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi.
Morning, Judge Nuku.
Good morning, Commissioner Nyambi.
How will you describe the performance of the Competition Appeal Court, especially in the last few years?
May I ask you to give me a context? Is it in terms of the matters that have been finalized that come before it, or just to help me understand the question properly?
I'm referring to matters that have been finalized by it, given your acting stint and your experience as you have been part of it for the past year and now.
The matters that have come before the Competition Appeal Court, as at the time that I've been acting, and the ones that I've scoped in respect of the last 5 years, I get the impression that they are dealt with speedily, they are finalized timeously. But of course, there's this issue of a low number of case load for that court.
What are the immediate challenges that you think you will address should you be given opportunity to be part of the Competition Appeal Court?
Well, I have not particularly identified any challenges. I make myself available to that court so that I can contribute my understanding of competition issues.
Thanks, Judge Nuku. Thank you, CJ.
Thank you.
Thank you, Commissioner Nyambi. Commissioner Dodovu.
Thank you very much, CJ. Just one question for you, Justice. A number of bodies here acknowledge the fact that you write well, you deliver good judgments, but they also raise a concern about the fact that you have outstanding matters that you had partly, and that you have some reserve judgments, which is a concern. Can you please address us on that and indicate why you have delayed judgments? Thanks.
Thank you, Commissioner. The judgments I listed in my questionnaire were on the 29th of November. Those judgments are in respect of cases I had in that month, and all those judgments have been delivered. I had two partly heard matters that I mentioned in the questionnaire. One is a criminal matter which I'm doing on circuit. It's, I'm going to be finalizing that matter sometime in August. It's set down for 16th of August, continuing thereabout. The other one was, let me just think now, can I? But partly head matters were matters that were partly head as at that time. So in respect of delay, there is no issue of delay because those were judge matters heard in that matter. The part head matters, it's matter, you run a matter and then one counsel is not available, so you have to postpone and there's nothing much you can do. It's not a delay on the part of the judge, but it's just that you can't finalize the matter without the cooperation of the parties.
Are you certain that you were propelled by a burning desire to finalize your reserve judgments, or was it a malicious compliance because you were coming here? This is an experience that I've seen, that a lot of people have that, and at the time that they come here, they rush this judgment so that during the interview they say, we are done with that. And this is a recurrence.
No, that is a fair question, Commissioner, but I can tell you no, because the time frame for the delivery of the judgments that were outstanding as at that time is in line with the time frames generally in respect of which I deliver my judgments. I deliver my judgments timeously. Other than those matters that I listed as outstanding as at that time, I have not picked up that there is a complaint of me delaying the delivery of judgments.
Thank you, CJ.
Thank you very much. Commissioner Matolo-Tlepu.
Good morning, Judge Nuku.
Good morning, Commissioner Matolo-Tlepu.
My question is just a concern regarding, the lack of competition lawyers and competition judges. I mean, it's a concern of this commission that there are very few. We have shortlisted only two. And there's an outcry from especially black legal practitioners that we are not exposed to competition law. Most of us have done all those courses and nothing is coming our way. But what do you think can be done to frustrate this? Because it's becoming actually a disaster now. What do you think, in your own view, what do you think can be done to make sure that smaller firms get access to competition law and actually we get more applicants to be judges?
Commissioner, that's a very difficult question because my assessment of the competition law space is that most of the parties that litigate in that space are big corporations, private corporations. And I need not say that, unfortunately, they have no commitment to transformation. The Competition Commission plays its part. It does, I know, instruct black attorneys. I know it instructs black counsel to lead the team. So the market, the players really, there is the Competition Commission on one hand, and these big private institutions on the other hand, who kind of seem married to their big five, if I may say that. So it's really a difficult question for me to answer. I also have been, that's my experience as I was a practitioner, as I was narrating. I had always hoped that I would be able to break into that space. But unfortunately, the private companies don't seem to be keen on utilizing the services of black practitioners. An experience I had many years ago where I had been invited to do a presentation in one of the big insurance companies. I got into their offices and I thought I could get a chance because the person that I was talking to was a black person, but he told me something that was very disheartening, that for him, his bosses will understand if one of the big 5 law firms loses a matter. But if my small practice loses that matter, he may be fired. So there are those considerations that are out there. And how we address that is a big challenge.
Thank you, Justice.
Thank you, Commissioner. Judge President Mlambo.
Thank you very much, Chief Justice. Judge Nuku, good morning.
Good morning, JP Mlambo.
And I want to thank you for availing yourself for this position. It shows that you are serious in the advancement of jurisprudence, especially by black jurists. Let me put it that way. I note that in your questionnaire, you've listed something like 8 or 9 judgments which were reversed, your judgments which were reversed on appeal, and you list 4 which were unsuccessfully appealed against. And I'm just curious, have you had more reversals than affirmations in your career as a judge? Or don't you track that? Like me, once I've written a judgment, that's it.
I only track those ones where the matter is ultimately heard. As you would know, you would hear a matter, you make your decision, there's an application for leave to appeal which you dismiss, and then the parties petition to the Supreme Court of Appeal. I'm not able to track those ones. So I would not put them in the mix.
Okay.
So if those are to be considered, I am certain that there are more matters that have not been successfully appealed than those that were successfully appealed. And then again, coming to those ones that were successfully appealed, I've reflected on them. If you look at them, except just for one, all of those matters are matters that I had in my first 3 years, my appointment, including from 2015. So the last matter would be 2018. And those were complex matters. I have reflected on those matters and I've learned a lot from them.
Thank you for that. Have those judgments in which you were reversed, was there any adverse comment by the appeal judges against how you handled or how you approached the matters?
Broadly, no, but I think there is one matter where the SCA was a bit critical of my acceptance of the deponent's evidence. There is also another matter where not harsh, but it was critical of the manner in which I dealt with agreed facts between experts. I think and then there was, I think there were some, those were the critical comments. But I was not harshly criticized, but.
Thank you very much for that. I've got 2 more questions. One is, I think the Chief Justice took you through your experience, especially in competition law matters. We all come from the same boat. We never even had a whiff of competition law matters when we were in practice. Now, you say you wrote two judgments. One was a minority judgment. I'm interested in the other one, where you say it was unanimous. How long did it take you to write that judgment?
We had that, I think, just over a month. We delivered judgment on the 24th of March. We had the matter during February.
I see. Okay. I've got two comments. I think I'm just interested in your comments to the comments I'll make to you. If you prefer not to make a comment, that's fair. The first one, I think the Chief Justice gave you the example of the Labour Court and the Labour Appeal Court at some stage, that it had more labour law specialists in the Labour Court than in the Labour Appeal Court. And someone who may be sitting in this room coined a phrase to deal with that, to say, if you are sitting in the Labour Court and your judgment is reversed by the Labour Appeal Court, you should celebrate because you are correct. And that if the Labour Appeal Court upholds you, you should be worried. Do you have a comment to that?
I would rather not comment on that.
Well, one more. The current Deputy Judge President of the Northern Cape, when she was approached to act in the Labour Appeal Court, she confessed that she had no experience in labour law and requested that she be first appointed to the Labour Court and do some time there before she's considered for the Labour Appeal Court. That was acceded to, and in later years, she actually deputized for long durations as the Judge President of the Labour Appeal Court, having gone through that experience of the Labour Court and then Labour Appeal Court. What do you think of that approach? Just to deal with people who say, I may not have enough competition law experience. I don't know what the regulatory environment is, whether judges can be appointed to the competition tribunal, but I'm just asking, do you have a view about that?
Well, I think in respect of the tribunal, I think there is no scope for judges' participation there. So there is a statutory issue there that would prevent that from happening.
Yes.
But once again, I think it's something that has got to do with how a particular person views his or her shortcomings. And as a way of addressing them, that may be a viable option, as the example you make demonstrates.
Yes. Thank you very much, Chief Justice. I've got no further questions.
Thank you, Judge President. I don't see any other.
I do, Chief Justice, I'm afraid.
Okay. Yes, please go ahead.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner Ngwaitobi.
Yes, I just want to follow up the point that was made by your Judge President in the CAC about your philosophical approach to competition as a starting point. But I want to make something tangible so that I can tease out precisely what your philosophy is, because there's, someone can say, I reject the Chicago school, but only to find that they are Chicagoists in a closet. So I do want to explore that. The Competition Commission published its findings. They were launched at the Competition Annual Conference last year on concentration levels in the market in South Africa. I mean, the findings show that in the last 20 years, there's been more concentration than less concentration, and that small and medium enterprises, let's call it black firms, that have tried to enter the market have exited on an average of 2 years, which is an illustration of high barriers to entry, also an illustration of how market power is abused, and also finding that, generally speaking, competition policy has been ineffective as an instrument of disciplining the exercise of market power, right? Yes. So that's the context to my question. So I want to ask you whether you think deconcentration of markets should be a goal of competition policy. Because even there is a debate about whether deconcentration per se should be a goal of competition policy, or whether deconcentration only with an anti-competitive element should be a goal of competition policy. So on that philosophical debate, where do you stand?
Deconcentration, which has the results of preventing the participation of black firms in the market, is a problem that should be the concern for the Competition Commission and the competition authorities. Hence, I say that the issue of the market inquiries is, in my view, one of the tools that can be used to deal with the structure of the market.
No, I'm asking a different question. Do you think deconcentration per se should be a goal of competition policy or not?
Not in the abstract, Commissioner. As I said, deconcentration which has concentration or disconcentration which impedes participation by small and medium enterprises and those firms owned by historically disadvantaged persons is, in terms of the Act, a concern for the competition authorities.
Yes.
I'm not sure if
No,
we're talking past each other.
Yeah, I think we are talking past each other, but I'll leave the question because I think that's the very debate is some people say concentration is not a problem, right? And others say concentration is a problem per se. And that's what I'm trying to test because that's where you find this distinction between whether one is a Chicago School believer or whether one actually believes in our Competition Act as such. So that's what I was trying to explore. But I think you've said what you wanted to say on that topic and there's nothing else to add. Then I want to ask you something else about your own experience and how you can, I would say, mitigate on it. I mean, I think the elephant in the room, I think Judge Manoim, the Chief Justice, as well as Judge Mlambo are touching on this thing, is that people say, well, when we look at Judge Nuku's application, we can see he has potential, but we think that he doesn't have enough years, especially because he has not done competition law before. And you may say it's because of the structure that is racist and that's not enabling black practitioners to get in. So those explanations are fine, but where we stand at the moment is that you don't have the experience. So that's what I want to actually ask you to tell us that, look, this is not going to be a problem. This is what I'm going to do to fix the deficit in my skills knowledge, because I'm going to a court of appeal. And that court of appeal is very important because from there we go to the Concord. There is no other avenue of fixing the problems that come with the judgments of the CAC. So we've got to get really tried and tested judges. So that is what is being sort of suggested. And so I don't think it's an answer to say, oh, well, interpreting an economic problem is the same thing as interpreting an RAF problem, because it's clearly not the same thing. So something else is still expected of you to say to this commission, to this commission, to satisfy us that you are not a risk to an appeal court where we have no remedy. If we lose before you, we have no remedy, because the Constitutional Court is not going to accept cases except if they are unique. So you are going to be the final say on these topics. So that's really, I think, what is being tested is what can you say to us to be satisfied that you are actually a safe pair of hands?
I understand that question, Commissioner Ngoetobi. In answering Chief Justice, I indicated that it is for the Commission to evaluate what I have put in front of it. There is nothing more that I can say more than what my papers demonstrate. If on the basis of that, the feeling is that perhaps it's too early for me to be appointed, I can live with that and continue to act in the Competition Appeal Court if invited. But if the Commission considers my application and thinks that despite my lack of experience, I show good potential which should not be lost, that I can also live with.
Nothing else, Chief Justice.
Thank you, Commissioner Ngoetobi. Commissioner Kay.
Thank you, Chief Justice. Good morning, Judge.
Good morning, Commissioner Kay.
I'm picking up on, or giving you another opportunity to persuade me and others sitting here that notwithstanding your lack of experience in this field, you've gone to trouble to gather what the major debates are in the competition law enforcement area in South Africa involve. In other words, there are policy debates going on in relation to competition law enforcement, and I'd like you to indicate what those are and what you've done to grapple with them, if possible.
Well, the one issue that I picked up that seems to be of great concern to the Competition Commission is the issue of the interpretation of Section 41B of the Competition Act that prohibits certain conduct. And in particular, it seems to me that the concern there is a phenomenon called characterization, which was brought about by the Supreme Court of Appeal in one of the matters that landed in that court, where the Supreme Court of Appeal referred the matter back to the tribunal, saying that the tribunal must embark on this process of characterization. And by that, I understood it to be that what it was saying is that Section 41B needs to be contextualized properly so that when you evaluate a complaint that relates to that section, you are able to see if it's the conduct that should be condemned in terms of that section. Because there may be instances where on the face of it, the conduct at issue appears to be prohibited, but on interpreting that section properly and looking at the conduct may come to a different conclusion. That's one aspect that I have picked up.
I think that I'm looking for an indication of the broader debates, the policy considerations behind what competition law enforcement in South Africa should aim to address.
Well, I think my response goes back to my reading of the Competition Act, and in particular in light of the amendments, that our competition law is not concerned only with pure competition law issues. There are broader issues of public consideration, public policy that come into play.
Thank you, Chief Justice.
Thank you. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner Pillay.
Judge, I'm just mopping up on the adverse comments that have been made by bodies and persons, etc. And quite a few of my fellow commissioners have already dealt with a number of them. There is one outstanding adverse comment which I would like you to respond to. And that's that it was raised by one of the law bodies that you've got limited appellate experience. Now, I'd like you to address that issue, but I would like you to address it in the context of one of the matters that you mentioned, and that's the matter of B versus RAF, where the Supreme Court of Appeal was quite critical because you had gone behind the trial court's finding in relation to the joint expert minute. I don't know if you recall the matter.
Yes, I do recall. Thank you.
And the Supreme Court of Appeal found particularly that that was not appropriate for an appellate court to do. So perhaps I could ask you just to address the underlying concern that you've got limited appellate experience, and then just tie it to that particular matter and the finding of the SCA.
As I have indicated earlier, Commissioner, the comment that I have limited appellate experience is without foundation. Firstly, because of the appeals that we do weekly sometimes. And secondly, the full bench appeals where we sit on judgment in respect of matters coming from our own colleagues. The matter that we referred to is a matter that we had in July 2016. I had indicated earlier on that the majority of the matters that we overturned come from the first 3 years of my appointment as a judge, and I have reflected on them, and I have learned a lot from what the superior courts have said. The issue in that matter, there is always a debate, I sense, when it comes to the evaluation of expert evidence as to where to draw the line between the facts, the opinions, and an expert going as far as now dealing with legal position. I think in that matter, I felt that the agreement between the expert was not only limited to facts, and that is what I was criticized for, and I accept that criticism.
But you do see the difference in the role between a trial court's role and an appellate's court role in the handling of that expert evidence. I think that's the issue that the SCA touched on.
Absolutely, I do, yes. No, as an appellate court, you have no role in respect of undisputed facts, the facts that are common cause, to put it that way, because once they are agreed, they are common cause, you can't go behind that. But the difficulty becomes, as I was trying to explain, where in your view as a judge, this agreement is not just about the facts, but goes further than that, which I think was my mistake in that matter, which I accept.
Thank you, Chief Justice.
Thank you very much, Commissioner Pillay. I don't see any other hands. Commissioner Moiman.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner.
Just one question from my side in relation to your appreciation of the Competition Tribunal within the context of the amendment to the Competitions Act. I just want to get your appreciation in relation to what is your understanding of the Competition Tribunal? How does it relate to the Competitions Appeals Court and the Competitions Court? But more than that, how does what is your appreciation in relation to the work of the Competition Tribunal in relation to the abuse of dominance, how can the Competition Tribunal address the challenges with regard to the measure control regime? But more than that, the role of the Competition Tribunal in relation to its work around toughening the penalty regime as envisaged by the amendment to the Competitions Act. Thank you, Chief Justice. Thank you, Judge Nuku.
Thank you very much, Commissioner.
Thank you.
I'm told that we are going to have this load shedding from time to time, but as yesterday, it would be an interruption of a short duration, like 5 minutes. I think we are able to continue. I'm told that there are hands in the virtual platform who would like to put questions to the candidate there.
Thank you, Chief Justice.
Yes.
Clement Marumuahai.
Yes, please go ahead, Commissioner.
Sorry, Chief Justice, should I not first answer the question that was asked?
I'm sorry. With the load shedding, yeah, please answer the other question first, and then we go to the Commissioner on virtual.
Thank you, Chief Justice. Thank you, Commissioner. My understanding of the structure of the Competition Act is that we have the Competition Commission, which policies and refers matters to the tribunal, which is an adjudicative body of first instance. It also deals with the major controls. It then makes whatever findings it does, and those in respect of which the parties are unhappy would then come on appeal before the Competition Appeal Court. And in certain instances, its decisions may continue, Chief Justice.
I'm sorry, there is some noise. Just wait a bit. I assume technicians will attend to it. Okay, all right, thank you. You may continue.
So I was saying, and then some of its decision may be subject of review, which reviews then come to the Competition Appeal Court. And in my view, it can't really be for me to say how the tribunal should go about its business, particularly where I have made myself available to sit as an appellate judge in respect of its work. I appreciate that it does a lot of work. There may be certain areas where there might be criticisms. I think that goes with any adjudicative body.
Okay, thank you.
Thank you, Chief Justice. Thank you, Justice Nuku.
Thank you. Commissioner Marum Mwachai.
Marumo Wachai.
Marumo Wachai. I think you could tell from my demeanor that I was, I apologize, Prof, once again, but you can see I'm getting there with the training. Marumo Wachai. Oh, okay. I'll keep on trying. Okay, please don't be offended, Prof. Please go ahead. Oh, can you hear me on the virtual platform? Or maybe it's the effects of the load shedding. We need to wait a bit. Yeah, I think we'll just have to be patient a bit.
Maybe try Mr. Barnard. He seems to have his hand up, just to check if...
Commissioner Barnard, can you hear me?
I can hear you, Chief Justice.
Commissioner
says-
Barnard, can you hear me?
He says he can hear you, Chief Justice, but it's very faint.
Oh, but I can't hear him.
Yeah, it's coming from here, but the sound is very faint.
Yeah. Maybe we should take a 5 minutes break. Let's take a 5 minutes break so that they can fix the IT. Okay, thank you.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner Barnett.
I suppose first we must declare that we were at the Cape Law Society, and I know I visited your home village outside Mthatha at the time as a celebration of your permanent appointment, and enjoyed some of your community's hospitality. So maybe get that out of the way.
Thank you, Commissioner Barnett.
I want to just ask, my question is really just related to the dominance matter, the e-media and multi-choice. And it's really about the differences I want to ask you about, to perhaps explain to the Commission the difference between your approach and which was the minority judgment, and then the approach of the majority in that matter. It's, reading the matter, it seems you might have been more conservative in your approach than that of the majority, and maybe focused more on the merits, while the majority focused on the fact that it was an application for an interdict pending further competition litigation. So the question is, what was the difference in approaches there? And then the second aspect of that is, what did you learn from that matter having regard to both judgments? Thank you.
Commissioner Barat, I think the difference boiled down to the question whether I felt whether a prima facie case had been made of the prohibited conduct. The majority felt that the facts had made a case for an abuse of dominance.
Thank you. And what did you learn from that matter? If your experience of having a look at those two judgments?
It's difficult to say what you have learned in a situation where you write a dissent, because a dissent is not something that you write as a matter of course. You write it on the principle that you feel that on the facts before you, a case has not been made. But I accept the decision of the majority, as I must.
Thank you, Judge Nuku. Thank you, Chief Justice.
Thank you, Commissioner Barnard. Is Commissioner Prof available now?
He doesn't seem to be on virtual, Chief Justice.
Yeah. Is there someone else on the virtual platform who wishes to ask questions?
There are no hands up, Chief Justice.
No. Yes. Yes, okay, thank you. I had been given a message earlier on that I think I'm going to say Commissioner Prof until I've mastered the pronunciation because I don't want to do injustice to his surname. I'd been given the information that he was going to initially be on the virtual platform, but he would join us around tea time. So the Secretariat tells me that they've tried to call him now. He's not picking up. It may be that he's on his way. I'm not sure. So I just share that information with everybody. One doesn't want to conclude in circumstances where a commissioner had questions, but I think the Secretariat would need to keep on trying to get hold of him unless there's a different suggestion. Commissioner Malema?
CJ, that commissioner's surname has got two words. The first word is Marumo. Spears, Marumo. Yes. And then Agai. Marumo Agai. So Agai is A-G-A-E. So you call them at the same time, Marumo Agai.
I think you'd make a very good teacher, Commissioner. I think the way you have explained it is Marumo Ahai.
Yes.
Yes. You see, you are a good teacher.
But on a separate matter, CJ, I think if we lost Prof, it shouldn't be something that we can't proceed on the basis that is disconnected. So I think you have made several attempts. You tried, even the commissioners on the platform said it's not there. We still have a lot of candidates to go through.
I know. I don't know what is the feeling of everybody. I was just thinking in case he feels strongly about whatever he wanted to ask. That was my only concern. Let's start with Commissioner Nojesi.
I support Commissioner Malema without further motivations.
Yes, okay. Justice Spencer.
Thank you, Chief Justice. I also concur. He must either be in attendance here or
Yeah.
a virtual platform.
Okay. Is that what
So
you
he's
also wanted
neither
to say?
here nor.
Okay. Okay.
Yes,
It looks
thank you.
like that's the. Yeah, we all agree. Okay. Thank you very much, Judge Nuku. We have come to the end of this interview. Once again, thank you for making yourself available. You are now excused. Thank you.
Thank you, Chief Justice.